How are you? Feeling a bit of deja vu?
I'm feeling a bit of deja vu, yeah. You won't be surprised, understood this is pre-recorded, and we got halfway through and realised we weren't recording. So if we seem a bit stale, it's because we thought we did a really good first take. A good first take. But in our first take, when this is released, I'll be doing a presentation at Southeastern Business Network around board reporting in safety. And as I was reflecting on doing it, and I've created a draft board report, which I will share with you at some stage. One of the things that I realised that our consulting business regularly do is go into boards and teach them to build a governance charter, a safety charter of what boards will do. And as I was driving, and I was thinking, but that really is the heart of good board behaviour, isn't it? That commitment made where they all sign off and say, yes, we will stay up to date, and this is how we will do it. Yes, I will do this, and this is how I'll do it. You know, it really is the beginning of safety, is buying the front-end engagement of the board and saying, look, we promise to do this.
Yeah.
And that each year we will review our charter, we'll tidy it up, but we promise to do it. When the safety manager is not turning up with disinterested people asking about lag indicators like lost time injuries, they're interested in saying, so the systems are working, tell me, show me how they're working. We get a much better dialogue. Anyway, so look.
I think it's just great as evidence for due diligence, right? It's really minimum viable product.
It is, and we don't see it, you know.
It's really rare that we see it, actually.
And yet it's something which is a day workshop with your board, which actually produces a whole lot of momentum and excitement going forward, and immediately meets your due diligence requirement. In Victoria, it's Section 144 clean. It's Section 27 clean in every WHS jurisdiction. Yeah. It's such a good start. So talk to us about that, because I think it's a win, and it's a very easy win. Yeah. And it's a door open for OHS to have a voice.
And it will protect your officers.
Yeah. And if you protect your officers, ultimately you protect the business. Anyway, why don't we jump into our first case, which is
our first exciting case.
First exciting case. Can I just say today, Nina has come with a bit of a dark attitude to my case selection, as she stomped across the floor with a self-righteous look on her face. She said, "Not much happening this week, is there?" I chose the cases. You can pick it. I chose the cases this week, not Nina. But the first case is about Opal. It's around about the obligations of consultation for a drug and alcohol testing regime, where it changed it slightly. Why did I choose this exciting case? Well, I chose it for a really good reason. And the reason is nobody seems to understand what the consultation obligation is in safety law. Can I just say that regulators at the moment are prosecuting every single thing, not just one breach. Yeah. So they're prosecuting breaches of this, failure to notify, failure to preserve sites, all sorts of things, not just breaches of duties. So, but this duty means that when you're about to change something that is safety related, like a drug and alcohol policy, like how you operate a particular machine, when you're about to change it.
Or introducing a safe work statement.
Yeah, anything like that. Your obligation is to identify what is the problem you're trying to solve, to take the problem and the solution to people, and say, look, this is what we're thinking about, this is how we want to go about it, we need your feedback. You're not after their consent, okay? That's the mistake. People think if I talk about it and they disagree with me, I can't do anything. Rubbish, you can. Yeah. But you then have a system of documentation and clarity that shows the decision you're making is the best decision, but people have been consulted. And the union's engagement is to try and make it be to frustrate what you're trying to do, but at the end of the day, they'd lose if the consultation's pure.
Yeah, I think it's like a very common thing that people hate consultation, because it seems almost like there's no point to it, because you're going to implement it anyway. But this case is a reminder that if you don't just do it properly, it's going to cost you more to get to the same result anyway.
And the other part is consultation, although it brings unions through the door and they argue and fight, it cleans them out, because they have no power of the consultation. Yes, they'll try and bureaucratise it. Yes, they'll try and have their say. Yes, they'll try and
drag out the process.
Yeah, but at the end of the day, for an organisation the size of Opal, who's filled with AMW trying to get through every door, the most important thing is every time you land in a tribunal of any sort, you win, because that's the best smack in the face for a union. And here's a case which was they've lost, but had they have gone through the consultation process, that would have been another whack to the union on the way through. So remember, unions are very limited in what they can get through the door with this day. So we're going to see us constantly around delegates' rights being exercised and attempts to show that you're breaching those obligations. We see it around psychological hazards in the last 5 years. We see it around safety. But they're losing impetus. They're losing capacity. We do these things right. We are always the white hat. They are the black hat in the commission. That means we gain the better relationship with our employees. So I think it's just a great story. I agree with Nina, it's not the most fascinating law, but it's good. And it's equally as fascinating as the next case that we're going to deal with, which is the shareholder issue.
I think they're just missing the drama of some of our usual cases.
Yeah, I know you are, yeah. And I'm not finding ones that have swearing and things like that because I thought I'd stop being puerile. But this is a really important case, not a legal case in the sense of being important legally, but for family-based business. And they make up a large section of the Australian working community and they fill the SME space. So the over 5 million turnover to 100 million turnover filled with generational family businesses. And in that, you get people who aren't first generation, who are not the skills that existed beforehand, but they're unable to have clarity of their role as an employee versus their role as a shareholder, or an implied right they've had for a long time by just being a family member to be able to vent or disagree, which of course is contrary to obligations of employees to always act in the best interests of the business. Now, in this case, an independent chair was brought in to try and resolve the conflict that sat within a family. It's pretty clear that that person and other people who were the employer generally made the decision, this is not working with this particular guy.
Yeah, and they had found that they had engaged in misconduct as well.
Yeah, so the evidence was there. They cut through the procedural part of it because I think they thought it'd probably blow it up. We don't know that, but I think that's where they're good. And if they did it, when I look at what the decision says, I think that was a strategic decision which said, look, it's going to cost us a bit of money, but this guy will never be reinstated. And that's what the commission did. They said,
and to limit further damage. Yeah.
So what they've done is as lawyers, we're meant to always reflect what the best law is. Sometimes the best law is wearing a cost on one side to get an outcome here.
Yeah.
In family businesses, there is a need for clarity, precision and speed when you are taking on members of family because they have such an investment and such other links within the family and the community that the normal processes will fail and you'll have people on workers' compensation claims, you'll have other costs associated with it. Does that mean this is the end of the matter in this family? I suspect not. I think there'll be other issues as clarity is brought to the business about what success looks like. But remember, the law is not always us. The first case is how to comply with the law. The second case is, well, when do I not comply with the law? What is the cost and what is the outcome?
Yeah, you pursue practicality of the law. Yeah.
So I want to juxtapose those two cases to show you what good law looks like when it's executed well in large industry and most of the time for you. And sometimes you just got to pull the lever. All right, well, look, that's that case. Why don't we jump on to the next one? And the next one is guidance around safety.
Industrial.
And look, what a nonsense. Where are we getting to with the law? This is a case in the electrical industry where the actions of workers during strike action posed a risk to the community. And therefore, the employer sought to suspend the industrial action.
For 2 months.
And
they got it at first.
They got it first instance. But then the full court said, but the behaviour that you're complaining about is unprotected action.
Yeah.
And therefore, we can't issue these orders. So what you really should have done is brought a stop work action or an injunction to try and prevent it.
It was a really, really technical argument.
And look, I get it. I'm a lawyer. I love law. But 25 years ago, when I used to go down to the Industrial Relations Commissioner, one of the old union organisers who was a commission would have looked at the union and said, don't be dickheads. You're not going to do this. I'll stop you. Now, is it better that the law is more functionally and actually dealt with now? I guess it is, because now anyone knows when this risk is posed of unprotected action in the sense that it goes outside the responsibilities of safety. So part of protected action is it will never be protected if it creates a lack of safety. Okay. Then you bring the right action to prevent it. But isn't that a nonsense while people's lives are at risk? And I think at some stage, surely a commission can go, look, I'm happy if you'd amend on the run with this because lives are at risk.
Yeah.
And if there's costs associated with that, let's deal with it. And I'll give a short order way you can. The lack of flexibility, the lack of community responsibility in doing That bothers me.
Yeah, it was purely focused on the law, not the practical realities of the situation.
Can we go on to Facebook?
Yeah. Go on to Facebook.
Why I have Facebook? Every month we get people come in and say,
this is so common.
Yeah, well, this is just day by day. Look, someone's injured, says they've injured themselves at work.
Or has taken the day off because they're sick or whatever.
Yeah, done all that sort of stuff. And look what they're doing on Facebook. So you might remember Anderson and the Crown, where the guy loved Essendon, tried to take off personal leave to go and see the last game in Western Australia, and Sheedy's last game as coach. They said no, so he got his doctor to give him a certificate, and there he was in the crowd waving his scarf
on
TV, and the court said, yeah, bad luck, you're fired, gone. And somewhere along the line, people have become really emboldened with this idea. And, you know, there's a great warning in a case called Marshall and the Commonwealth, which was the BOM. What's the Bureau of Meteorology case?
Yes.
Yeah. And he was on Beauty and the Geek, and he was one.
Oh, yeah, that's a great case.
He was the geek.
Yes.
And they fired him because he was on this show and said that he was psychologically unfit for work.
No, so it's the other way around. So he said he was psychologically unfit, but then they found that he was on the show for like a whole season. Yeah.
And so they fired him. And what was found in court was the doctor had actually told them, this is actually good for such a shy man who's struggling to actually go on a show that builds these skills with him.
Yeah.
Okay. And I just read that, and the judge's comments were disbelieving, but understanding why he was disbelieving, but saying the medical evidence is unequivocal.
Yeah.
And I get it, and yes, it's unfair. This is the same as this case here. This is a guy who had a psychological issue. On Facebook, he went away. He actually went away overseas.
To a wedding.
Was dancing, playing guitar, smiling. They sacked him. And I get this. I was just saying to Nina before our first fail take that my first personal injury claim was a guy who injured his back, and I was cross-examining him in the Supreme Court, and we had videos of him changing the tyre on his car, and he couldn't do that. That's one of the things that was absolutely clear he couldn't do. I think that our private investigators a long time ago actually may have punctured that tyre. I'm very embarrassed by that now.
Oh my gosh.
But nonetheless, when he gave the evidence, he said, yeah, you can see me doing that. And yeah, I'm not wincing. He said, but what you're not seeing is how I was for the next 3 days.
Mm.
And here's the medical evidence of the impact of that on me. And I can remember sort of crawling up in a ball and going, yeah, you see the obvious and you think it means something. And not a week would go by where I don't say to a client, look, I know the person said they're depressed and you saw them down the road having a coffee with a friend and smiling. It doesn't mean that they're not sad. It doesn't mean they're not depressed.
It's circumstantial evidence as well.
The best evidence is the medical evidence. So in this case, there was no attempt to actually test his position or to test it with a medical practitioner as to whether that would demonstrate his incapacity to do it, and therefore they failed.
Yeah, and had they done that and, dispelled all his claims, and they would have been fine to terminate.
Yeah, and if they hadn't, they would have found that they were a good employer who properly challenges stuff and goes, good, look, you did the right thing, we understand it. But people aren't going to tell you things like that when they have an employer who goes on Facebook and just terminates it.
Yeah, exactly.
Sydney Trains, what's this case all about? It is a bizarre, this is a bizarre case for a guy with ADDH who went along to his medical to get his medical test before he starts. He disclosed to the medical examiner, who was engaged by the employer, that he did have ADHD. They said, don't worry about it too much.
No. So
I got that wrong.
He failed to fill out the form and didn't disclose it. So they later found out he had ADHD, and they said, look, because of the safety issues and his safety critical role, they didn't think he could perform the inherent requirements of the job, so they terminated him for that and dishonesty. But then he, in the appeal, said, well, I spoke to the independent medical examiner and I did say I have this condition. They said it wasn't an issue.
So we agree on that. That's what I said.
Anyways.
I'm struggling.
Anyway.
I got a backhander and I was right. How did that happen? I'm going to sit back up here again.
Anyways, he said that was the whole reason. It was discrimination purely because of his condition, and the appeal court found no, there was more than enough evidence to prove that it was to do with inherent requirements.
Yeah, and I think this is one of the interesting issues, isn't it? Because it's been remitted back both for mediation and then further discussion. But the issue here really is the fact that someone has a disorder doesn't mean they're not fit for the inherent requirements.
No.
But if their demonstrated behaviour suggests it, then that's a different issue. Okay, so that's step one. Step two is, what is the nature of the risk in the role? Here, this is driving trains. Okay, it has an incredibly high level of risk that attaches to it. So the level of satisfaction of inherent requirements is obviously much higher. And that's what the appeal court was wrestling with, saying, well, look, there is this evidence showing you're not capable. You didn't disclose, and that's a real problem, the manner in which you didn't disclose, because the nature of what went wrong related to the nature of your problem. So there is a causal connection. So let's go back, see if you can fix it. But if you can't fix it, let's go on and deal with the issues properly. So everyone is on notice. But I think, for a family, I brought up kids who have mental health issues and had been excluded from roles because they were so candid about their illness at times, and yet it had no impact and they weren't entitled to be asked about it. But it's a terrible thing when you do suffer some disability to try and work out whether it is something you ought to disclose because it goes to the inherent requirements. And at that stage, can I just say, if you're the employee, go and chat to your doctor, to the expert doctor who's looking after you, and say, look, is this something I would need disclosed? This is the nature of the role. Because at that stage, you're not being dishonest. Dishonest is an intention to deceive. If the evidence is it's not appropriate to disclose it and it risks you being treated differently, and I can tell you now as an employer, if I get that and I see you've got this issue, it's raising a flag for me that I need to think about and need to be satisfied we can actually adjust to. So I think this is an interesting case because I don't think it gives us answers. What it does is raise a whole lot of questions. What are we up to after that?
Industrial manslaughter.
I think that's exciting, isn't it?
Yeah,
Every jurisdiction.
I think this is the most exciting thing from this.
I know, because you're a black letter lawyer, So Tasmania's up and running since...
So Tasmania passed it last week, a couple of days ago, but New South Wales is actually in effect from the 16th of September.
Yeah, okay, 25 years. So the highest penalty, isn't it? It's 20 million, but
Victoria's probably going to
surpass it because we use penalty units in Victoria, not fixed sums. So we're at about 19.8 million at the moment, aren't we?
Yes.
Something like
that. Yeah. But isn't it great after how many years that we've been asking for harmonisation that finally we've got them all to have IM?
Sort of.
Yeah. No, but I'm saying this is a
penalties.
step. Yeah.
I know, it would have been nice if we all got together and said, okay, so now we've got Northern Territory with life in prison and we've got the ACT with 2 days. Sorry, ACT. But the ACT penalties are just weak as anything. But my issue about it all is, once again, everyone's gone off and done their own thing. It's taken us 5 years to get industrial manslaughter or workplace manslaughter in Victoria passed. We've now got psychological code and regs in nearly every state and territory, except one of the person who pushed it hardest, which was Victoria. Isn't it about time, legislature, we just got our act together and said, there is no upside for business or for safety in having different laws. I can't educate a person to be a safety practitioner who can work around Australia without educating them on every single change they're going to... It's just nonsense.
Yeah, I agree. But look, isn't it a first step just to get it into effect?
Oh, you're a glass half full today, aren't you?
Yeah.
Yeah, this was yours. That's why you're talking about this. This was yours. Yeah, mine was all rubbish, but that was yours. Okay, well, I've got another case. So this is the geotech builder stuff. This is a really interesting little case. It's more of a vignette than a case, in the sense that this is a builder who had some geotechnical stuff, who said to build in a particular way would be unsafe. To get it done quickly, they started building, ignored the geotechnical advice, and as a result, both the buildings they're building and nearby buildings started to crumble and fail. They got a very significant fine.
180K.
Yeah, which would have, and it would have been 220 if it wasn't for an early pleading guilty, I think. But my point about this case is, imagine if there had been catastrophic failure and someone died. This would have been industrial manslaughter.
Oh, 100%.
So this is a case which is pure industrial manslaughter had there been a death.
Yeah.
Through a catastrophic failure that was causatively linked to the mistake, the failure to address geotechnical issues. So although this didn't have a catastrophic outcome, it did, environmentally it did in respect to the buildings, and for which there is a huge damages claim that's going to be taken separately by adjoining owners and no doubt by the principals who are involved in it. So this is a case which will have all sorts of bigger ramifications. But my point about this case is, when you're seized with evidence of what is a risk and you ignore it, if there was a catastrophic outcome, you're off to jail.
Yeah.
Throughout Australia.
Yeah.
Okay?
Yeah. Like they should have done underprivileged.
Yeah.
Especially if they've been ignored.
Well, even then, like the fact is, as an old building and construction lawyer, which is I am, once you have geotech is a risk-shifting exercise. So what you do is, if you're going to be the builder, we have an argument in the tendering process as to whose geotech we're going to rely on. So I'll do some as a principal, which will put you on notice of risk, which you'll have. So this person has been put on notice of risk. They've gone and got the advice, and the advice says the soils have these inherent risks.
Yeah.
Therefore, you need to address those. It wouldn't matter how you did that under privilege or not. You're a dead duck because you just go back to the tendering documents, and the court would say, well, you're put on notice. And you're there with your privilege report going, but you don't know what I know. It's a bit late because we do know what you don't know because that's what you tendered for.
Oh, so then it makes it
so in all building construction, all contracts, you look at how to shift risk. And part of it is, what is the experts you're going to rely upon to seek a builder to come in?
Yep.
And that puts you on notice. Well, you'd say, gee, they're very thin geotechs and there's no warranty given with it. Okay, that's my obligation. That's a cost that I have to do. And when I tender, I'll put that into variations and I'll liquidate damage. I'll put it into everything so I know that I can recover any change. And you'll find the contract has all those variations in there to address that risk. So privilege won't protect you in the end. Okay, well,
right,
let's go. We need to move on to the main topic.
We're running behind.
We're running behind, are we? How are we going for time?
We're at 21 minutes.
We're at 21 minutes. God, I'm really, for the second time I'm garrulous, the second time round. This is a really simple safety case. This is a case about a safety practitioner who, when confronted with an organisation that wanted to separate a report out into some part privilege, some part direct findings, in their own concrete way, became offended and thought, this is a breach of due diligence obligations, and if it's under privilege, you're not going to do anything. Now that's, can I just say that's so concrete and so wrong. We constantly use privilege to capture levels of risk which are structural or organisational, to understand how we can address those using the resource of the organisation and deal with the specific issues now through findings. But this was an unsophisticated safety manager who felt they were being thwarted, that there was a desire to hide safety, and then started to behave badly by sending documents home privately.
And to other people as well.
Including his girlfriend, not the wisest thing to do, but not terrible behaviour. But I think what the organisation can see is this is a person who's flailing, angry, and starting to do dangerous things. We can see where he's going with it. We need to stop it. And we terminate him. And he relied upon discrimination under the safety law, in that because he was raising safety issues, his employment was terminated. You remember early Patrick's case and a series of cases around safety discrimination. I think it's really important to understand that safety discrimination does exist under safety law as a general protection as well. Okay, so there's two different, and it does have a reverse onus. But don't push the wrong barrows. Okay, here was a person who, had they have reflected on, well, what was the intention of doing it under privilege? Why were you doing it? And asked the right questions rather than being confronting and antagonistic and destructive, would have realised that he could be a player in the big game of doing great things with safety rather than being an antagonist who just threw bombs.
Yeah, well, it probably also comes down to the communication that they had with him.
Yeah.
Had they kind of explained it a bit more, you don't have to waive privilege to do that.
No.
Maybe he wouldn't have been so adversarial.
Yeah, and I guess for our employers, the issue is, if you're going to do something which has major safety repercussions, do bring in your safety manager in the privilege protocol and engage them in what are the outcomes and how you're going to achieve it, so they can get the clarity and they understand that their concerns are being addressed. Because safety people are believers, like they're people who quite properly want to execute in a way that makes people go home safe every day. So look, interesting case. It shows how safety law does have these levers that can be used by safety practitioners or operational people where they're prosecuting a safety issue and they're treated badly. But here's a case where an employer doing the right method to preserve their own protections from safety regulators but still executing their duties was bumped into by their safety manager. And the safety manager started acting in manners which were unlawful in their role as an employee. So good case. But let's get on to the case study. Now you're reading, so I haven't put it in very hard words.
Dee was worried. Her employer's super strong build, SSB, a large-scale commercial builder in eastern seaboard major cities, was not listening to her. She had raised the failure to enforce SWIM's processes with contractors and the lack of commitment to a high-order controls strategy to manage complex sites. Her boss, Cliff, head of operations, had told her to pull her head in and make sure she was out on sites doing the detail. She explained she couldn't be everywhere, and Cliff's foremen were old school. If she was not there, they bent and sometimes broke the rules. Cliff promised to chat to them at his town hall leader meeting the following Monday. On the Tuesday after the town hall, Dee attended 3 Melbourne sites. In each, she observed unsigned swims, repeated breaches of traffic management, and scaffold obligations. Frustrated, she wrote a terse email to Cliff, copying in the executive group about her findings. The email was flavoured with her frustration and anger. It contained photos of the obvious breaches. Cliff rang her and said very directly she needed to stop what she was doing. If anything went wrong, WorkSafe would gain access to such emails, and she was exposing him and other executives to risk of prosecution. He invited her to a show cause meeting for obvious breach of obligations as an employee. She went and saw her GP, who filled out a certificate of capacity saying she was wholly unfit for work as she was suffering from PTSD and anxiety relating to her fears of injury and death at work from SSB's failure to act. That weekend was her daughter's 6th birthday. There were photos on Facebook of her singing happy birthday surrounded by family and school friends of her daughter. On the Monday, SSB issued her with a show cause notice as to why her employment should not be terminated, as she was obviously fit for work, copying in the Facebook post. Her Facebook had full privacy protection.
Okay, Durasec is the leading Victorian case and probably the leading Australian case. It's a Court of Appeal case on your rights to go into Facebook sites. And you're allowed to go into Facebook sites on full privacy settings under privacy law where you're undertaking an investigation were you to notify the person they may be able to remove a post. So I don't think that there's too many arguments about the entitlement to look at a Facebook.
No, but they didn't do the investigation or put it on notice.
That's right. And so the issue here is the flawed process probably blows their privacy protection and they're at risk straight away for the use that they've done. They certainly didn't put that to her as part of any investigative process. So do the Facebook posts demonstrate that Dee is fit for work? Well, no, they don't demonstrate anything. You know, there's times when I've been under enormous pressure at work and I've gone to family functions and been the life of the party, then gone home and had to work for 6 hours and been distracted really all the way through it.
But also the nature of the injury itself is psychological harm caused by work and PTSD from work. So logically, you could be in a different situation and not feel the same. So that it makes no sense.
Yeah. Does Dee have causes of action under safety law, discrimination and general protection?
Yes, she does.
Absolutely. So she has rights under illness protection as a protected attribute for discrimination.
She made a complaint.
Under safety law and screen's telling us things. Under safety law and a variety of other issues, she has general protection requirements, so which are workplace rights.
And she has a right to a safe workplace as well.
So there you go. So yeah, she's got good protection there.
Yeah.
Number 4. Let's see what our next question is. Would Dee have succeeded in a workers' compensation claim? Yes, she would without doubt. Okay, because she has an injury in all jurisdictions, which is the basis, the triggering point.
And it caused to do with substantially arose out of work.
Yes, that's fine. Were there general safety breaches, and if so, and by who? Yes, there were general safety breaches of not providing with a safe place of work. And there was much more substantial breaches of primary duties and perhaps reckless endangerment in relation to those major failings around scaffold and traffic management. So there are broader risks that she identified, and they're absolutely right. Her comments, the Section 100 notice in Victoria and comparable 155 and 156, I think it is, on WHS, also would entail the collection of all of that information and matters raised by her.
But that's not to say you shouldn't make complaints. Like, people have a right to make complaints and raise things so that they're fixed.
Yeah.
And if you do that, the answer is not don't put this in writing. Fix the problem.
But I guess one of the things here, and just briefly, because we are running a bit over time, I want to raise is you get to be able to raise complaints, you get to be able to do things, but in your role as an employee is a much more circumspect role. So what you can't do as an employee is do things that are not in the best interest of the business. So in this case, what she has done is in the best interest of the business. But the level of flavour she puts in of frustration can change that. So pointing fingers, blaming people, being destructive in the way she can do it can fall her outside of her obligations to act in the best interest of the business in accordance with the values of the business, which is a measure of what is good. So,
but I feel like if that were to bring a case, wouldn't the discrimination and the fact that you're taking it against her override the duties?
Well, let's just extend that and just say that she made a series of allegations in it which were not factually based.
Oh, I see where you're
were
coming from.
defamatory, destructive,
Yeah,
those sort
okay.
of things.
Okay, I
And
see.
the fact that she was exercising a workplace right wouldn't change the breach of her obligations.
Yeah.
Okay.
Okay.
So look, that's the reason I put the case, and that's the reason we've got a whole lot of funny cases that are in there today, is to come towards this final point of what we're saying is, remember, employees have specific obligations of behaviour that sit around statutory obligations, they sit around common law obligations. Safety is something which is preserved by all legislation and protected. So when you're acting safely, you do have protections that are in it. But I want people to sit back and go, okay, we're in the middle stage of getting into conflict. How do we get a proper consultation process together to move this change forward? And for our very beginning, how do I get this executive on board to deal with these issues rather than throwing confronting bombs at them? Now, imagine if a board charter had been involved at the beginning of this case and there was that engagement, none of the problems that Dee experienced would have ever occurred.
Yeah.
But what she was doing was fighting against the machine.
Yeah.
Okay.
All right,
great to have you along there. And I thought it was okay. I thought the case
okay.
weren't so bad. And thank you.
I don't know we'll have it next week because it's a public holiday.
Yeah, we'll come back to you on that. I don't think we will be having it's a public holiday. But
All right.
great to chat to you.
Give
See
us
you
thumbs
later.
up.
Bye-bye.